Hi, I'm Bruce Hammond with FloridaRealEstateZone.com. I want to tell you a little bit about an incident that I had on a closing recently. This was a short sale. We went for quite some time waiting for the seller's lender to approve the deal. In the meanwhile, while we were waiting for that, the house sat vacant for a number of months. And sometime during that time while we were waiting, between the time we went under contract and the time we got our approval and did our inspections, the house had been burglarized. The listing agent told me that the bank that actually didn't own the house, this was a short sale, so still owned by the owner, but the bank came along and changed the locks on the house anyway, and that the securing company for the bank must have taken some of the appliances out of the house. We were missing the stove and the dryer. And it had been so long since we went under contract that by the time we got to doing our home inspections, we noticed that these appliances were missing, but we weren't sure. It had been so long since we went under contract that we decided we better go back and check. We looked at our contract, we looked at the pictures and the multiple listing, and indeed they showed the dryer and the stove there. So I questioned the listing agent about this, who told me that, oh, well, these things must have been stolen. And I said, well, but the contract calls for the house to be maintained in the same condition as it was when we went under contract, so somebody needs to replace these appliances for my buyer. I was told, well, it's being sold as is, and it's too bad, and there's nothing they can do about it. They're not going to buy any appliances. The seller was not in a position, so they claimed, to buy any appliances, so my buyer could just accept the house as is, or they could cancel the contract. Obviously, there was a third option, which was to file suit for specific performance under the terms of the contract and to get those items replaced. If these were indeed stolen by the bank securing company, then I consider that to be a burglary, and they should call the police and report it. None of that was done by the listing agent. They basically just said, too bad, accept it the way it is. This answer was obviously not very acceptable to my buyer, but the approval that we had received from the bank was only good for a few weeks, and it was likely that it was going to take longer than that to resolve the issues over the missing appliances, so my buyer went ahead unhappily and closed on the deal. Closing does not necessarily preclude her from filing suit against the seller for the missing appliances, and that is something that she may do. She's been talking to an attorney about that, and that may happen. But my feeling is that if a house is sitting vacant for weeks and weeks and weeks, and either the listing agent or the seller goes to the house to check on it, that it is likely that there is going to be a break-in or some kind of vandalism or damage to the property, and that the listing agent and the seller were, in this case, both negligent in their duties to protect the home and to protect the property from the theft of the appliances or any other kinds of vandalism or break-ins that may happen. Here in Port St. Lucie, there are dozens or probably hundreds of vacant homes around the city. Many of them are in the process of foreclosure and just sitting there empty. Neighborhood kids get into them. Critters move in. I had one where a raccoon had made a nest in the attic and was raising babies up there. So all kinds of things can happen to the property, and it is incumbent on the listing agent and the seller to maintain the property and to make sure that nothing is missing and no damage occurs. In this case, the securing company had apparently, according to the listing agent, changed the locks on the house some 5 or 6 months before the closing actually took place. So there was a long period of time where this issue of missing appliances could have been addressed, but my feeling is that the listing agent was absolutely negligent in checking on the property and making sure that the property was maintained in the same condition as it was, as they have a contractual obligation to do so. Now, I'm no lawyer, and I'm not qualified to interpret the clauses of the contract, but my feeling is that it's quite clear in the contract that they have an obligation to take care of the property and to maintain it in the same condition as it was when the contract was accepted. So just something, if you're in a transaction where it's taking a long time to get the bank to approve a short sale, I would encourage you and your agent to regularly check the property to make sure that it is being taken care of, because if the listing agent isn't going to do it, then you as the buyer probably ought to protect your interests and ask your agent to allow you access to the property, every few weeks, at least once a month, something like that, just to make sure that everything is being taken care of and the house hasn't been invaded by pests or I guess animal or otherwise that might have done damage to the house or stolen things out of the house. This is Bruce Hammond with Florida Real Estate Zone. That's just my 2 cents for today. Feel free to give me a call or shoot me an email if you have any questions or comments or concerns. Thank you very much.